Hey guys, today we're going to talk about shadow directors. Now, what is a shadow director? It is a concept under company law which essentially refers to puppet masters, people who control the board. A shadow director would fall under the definition of a director under the Companies Act because he would be a person in accordance with whose directions or instructions the majority of the directors of a company are accustomed to act, therefore a puppet master. In the case of Raffles Town Club and Liming Hawk Peter, the court explained that the difference between a de facto director and a shadow director is that unlike a de facto director, the shadow director does not claim or does not purport to act as a director. In fact, he claims not to be a director, but is actually controlling the board of directors from behind the scenes like a puppet master. In the case of Hydro Dam, the court laid down the 4 requirements that have to be proved in order to establish a shadow directorship and the liability of a shadow director. So, the first requirement is proving who the directors of the company were, whether de facto or actual. Number 2, it has to be proved that the alleged shadow director instructed the directors on how to manage the company. Number 3, it has to be proved that the directors acted in accordance with his instructions. So, under the Interpretation Act of Singapore, a person is defined to include a company. So, given the literal interpretation of the definition of directors in the Companies Act, a holding company, so this is a subsidiary, a company above that holds all the shares in this company is called the holding company. A holding company may be said to be a shadow director of its subsidiaries, as in most cases, the directors of the subsidiaries would be accustomed to act instructions and directions of the directors of the holding company. In the Australian case of Standard Chartered Bank of Australia and Antico, the court held that a holding company with only a 42% shareholding was held to be a shadow director of the subsidiary, because the other shareholders of the company held very small percentages, 10%, 12%, 6%. So on that basis, the court found that the holding company acted as the shadow director. So based on a literal reading of the definition of directors under the Companies Act, it will appear that shadow directors are subject to the same statutory obligations under the Companies Act as directors who are persons, and so they have to abide by the duties to act honestly, to act in the interest of the company, to act for proper purposes, not to divert business opportunities, not to misuse confidential information. Otherwise, if this were not the case, then the duties and liabilities that are imposed by the law on directors may be circumvented through the unscrupulous use of shadow directors. What this means is that people can try to avoid their director's duties by essentially setting up another company to act as a shadow director of this company, and then escape liability from the director's duties. So the purpose of the definition of directors under the Companies Act to also include a company would therefore prevent the companies that are set up as holding companies from escaping their duties under the Companies Act and at common law. So regardless of whether a company is set up to be the shadow director of another company, or regardless of whether there is someone else who is not appointed as director but nonetheless gives instructions to the directors of the company, in other words a puppet master, it is difficult to argue that the law allows the puppet master to escape the duties and liabilities of being a director if he indeed acts as one, even though he's not formally appointed, because why? He controls the board. So thanks for watching this video on shadow directors.